transmission of shares with respect to cooperative housing society. Now, what is transfer? What we are trying to update you, or what I am trying to make you aware is, what is the difference between transfer of share related to your flat in your cooperative housing society, and what is the provision related to transmission of share? What are the consequences if you don't have nomination, if there is a nomination, and if there is no nomination, and if we have to do the transmission, or if we have to transfer the flat. So what is transfer of share? Normally, if I am buying a flat in a society as a resale, there would be transfer of share certificate happening, where you have to pay maximum 25,000 as transfer premium, and the society will have to ask you to give the documents, like you will have to give the register agreement, stamp duty paid agreement. You will have to intimate your society 15 days well in time that you are going to sell this flat. Then the set of document, the transfer set includes your application, the application of the proposed member, that is the transferee, that he wants to become a member, your resignation letter, the indemnity bond, the affidavit, the register agreement with the stamp duty paid challan and all. So these are the minimum documents which a housing society committee members, they should take on record. And once the person gives an application and he submits all these sets, he pays the incoming member pays the entrance fee to become the member. He fills up the membership form along with these documents. There is a 500 transfer fee is being paid, and 25,000 maximum transfer premium is paid. The society committee member, they have to take this transfer application in the next committee meeting which they are going to deal with. They have to dispose of this application in the next committee meeting. So this is about the transfer of shares. Now, what is transmission? Transmission happens when there is a death, right? Let's say there is a flat in the name of Mr. A. Now there is a death of Mr. A. So on whose name the share certificates needs to be transferred. So in this case, we do not say that it is a case of transfer of shares, or rather share certificate, but this is a case where we say it's a transmission. So here the transmission of share will happen, and that is why you find normally at the reverse or the backside of the share certificate the endorsement saying that transmission on so and so date, right? Now here, in case of transmission, the issue most probably that crops up in the housing society is when death happens. As you know, there would be legal heirs, they would come into picture, and each one would start approaching the society saying that I am the legal heir, this flat or this share certificate needs to be transferred in my name. Now how to tackle with this situation? Because I would like to make the committee members or this cooperative housing society committee members aware of one of the provisions of section 146, which talks about the offences, and the corresponding provision of section 147, which talks about the penalties. If the committee members are doing, there is an irregular transfer, that means if the share certificate is transferred irregularly, I mean you are supposed to transfer it in the name of, let's say, A, and if you have transferred it in the name of B, then you would be personally held responsible, and there is a penalty, which is, it can be an imprisonment along with the fine. So I would request all the committee member to kindly take note of this provision also. So before proceeding the transmission, what you have to see that whether the nomination is there on record or not. Let's say the flat is in the name of Mr. A solely. Now there is a death of Mr. A. We have a nomination on record. Let's say in the nomination form, Mr. A has nominated 100% of his flat to Mrs. A. Now, ideally, Mrs. A, she should come to the society within 6 months saying that this is a death certificate of my husband and kindly transfer the share certificate in my name. Now, in India, we are governed by the Hindu Succession Act as well. That means for the 100%, because he was the sole owner, Mr. A was the sole owner, for his 100% ownership, there are legal heirs which will come into picture. So legal heir includes his wife and his son or daughters, right? So that means ideally his wife is not the sole legal heir for the flat. But now I am trying to differentiate between the concept of membership in a housing society and ownership in the property. this is a confusion. There is a lot of confusion, and there is no clarity on this part in the housing society. What the housing society committee members feel when they are transferring the share certificate, that they are giving the ownership. I would again like to make it clear, make this point clear, that the housing society committee members, they are not dealing, or they are no way supposed to deal with the ownership part of the flat. What you are trying to do as a committee member is you are just trying to give the membership in the housing society by way of transmission of the share certificate. So if the nomination is placed on record, the committee members, the committee will take a decision, and based on the nomination, if the nomination is in the name of Mrs. A, the share certificate would be transferred or transmitted in the name of Mrs. A. That means the share certificate earlier used to be in the name of Mr. A. Now after his death, since the only nominee is Mrs. A, the share certificate will have the name of Mrs. A now. This is when there is nomination is there on record. Now let's say there is no nomination is there on record, and this is a situation where a lot of issues are being faced by the legal heirs also and by the committee members also. I would request all the committee members to kindly follow the bylaw provisions. Your bylaw specifically says if there is no nomination on record, then the committee has to give a public notice. Like let's say they come to know about the death of their member, of any of the legal heirs, they are approaching the committee to transfer or transmit this share certificate. The first thing committee members they should do is they should give a public notice in 2 leading newspapers saying that this is the flat in our society, this is the death of which was in the name of Mr. A. After his death, share certificate needs to be transmitted. So those who wants to object, and these are the members who have approached us for the transmission of the share certificate. So if anybody is objecting this, they should come forward, and you can give a time frame of let's say 15 days or 21 days or a 1 month in that public notice. The society committee member also needs to put up on the notice board that this is the claim for the particular transmission has come from the members. Then once you put up this notice, and if you give the public notice in 2 leading newspapers, then the society will, and let's say then there are claimants, then how to deal, whether there is one claimant, whether they are really legal heir, whether they are not legal heir, I mean how the society will take a call. So here the society, if there are 2 or 3 members, more than one claimant is there, so in that case as a committee you should ask them to give an affidavit first saying that in whose name the share certificate needs to be transmitted. So through affidavit, let's say there are 3 or 4 claimants that are coming forward. Through this affidavit they should say that okay, the flat can be transmitted in the name of Mrs. A first, and then the other 3 legal heirs, they will be joint owners or joint members in the share certificate. So even their names would be put in the share certificate, but after the person whom they have designated as the first person to be, whose name would be put in the share certificate. So along with this affidavit, normally the society members, they should also call for an indemnity bond. This is the indemnity bond which would be on 200 rupees stamp paper, which will be given by all this by the member who is then designated by this joint members. So that member would be giving the indemnity bond saying that in future if any litigation happens with respect to this claim of their share certificate, then they will indemnify the society for that kind of claim or any financial burden which the society will be facing because of that litigation. So this affidavit and indemnity is very much required, and society committee members are advised to take this on record. The other thing is, when there are 2-3, normally, see the word used in bylaw is may. So it is the discretion of the management committee to decide whether they are comfortable, and they can freeze whether okay, these are the 4 legal heirs. But as I said, there is section 146 which deals with irregular transfer. So normally none of the committee members, they would be keen to transmit the share certificate if there is no nomination on record. So in this case, the committee members, normally they will ask for the succession certificate or the letter of administration or heirship certificate. If this is being asked, if there is a will, then that will needs to be probated, and you can submit that probate copy to the society. The joint claimant, they can submit the probate copy if the will is there. If there is no will, there is no nomination, then succession or legal heir succession certificate or legal heir letter of administration or legal heir certificate is something which a society committee members, they should ask for, and then only they should transmit the shares. Now, whether this 25,000 maximum transfer premium which we are supposed to pay on transfer, whether it is required for transmission? No. So, if it is a transmission case, this 25,000 premium is not to be paid. And same thing with the gift deed. So, with this I will sign off. Thank you.